Let's get started. Good morning, everyone, and welcome. My name is Charlene Knight, and I'm the Director of Gift Planning and Lifetime Giving here at the University of Manitoba. The University of Manitoba campuses are located on original lands of Anishinaabe, Cree, Ojibwe Cree, Dakota, and Dene peoples, and on the homeland of the Red River Métis. We respect the treaties that were made on these territories. We acknowledge the harms and mistakes of the past, and we dedicate ourselves to move forward in partnership with Indigenous communities in spirit of reconciliation and collaboration. So wonderful to see so many of you. Good morning again. Before I begin, I'd like to mention that this session is being recorded and will be available on our website. There's a lot of information that will be shared with you today, and for this reason, we've decided to utilize the chat. Please utilize the chat for your questions. We will answer those questions at the end of our session, at the end of the presenter's presentation this morning. And if we don't get to them, because there may be many, please do not hesitate to reach out. Please do not hesitate to reach out to us, and we'll be able to answer those questions. Now, I just don't want to take a lot of time because we are starting a little bit late and there's so much information. So welcome to our Gift Planning 101 session. We are so pleased with the level of interest that we have seen for this topic, and we're even happier to be able to partner with experts in their field to bring this great information to you. It's my great pleasure to introduce our speakers to you today. Our first speaker is Andrew Torbiak. Andrew will be educating us on the ins and outs of will planning. Andrew is a partner with Tradition Law LLP Estates and Trusts in Winnipeg. Andrew maintains a broad practice in estates law with emphasis on estate planning and estate administration. He also provides consultation to clients related to committeeship and attorneyship issues, as well as to estate beneficiaries. Prior to being called to the Manitoba Bar in 2016, Andrew attended the Asper School of Business class of 2012 and the Robson Hall Faculty of Law, where he earned his Juris Doctorate degree in 2015. Andrew is a proud member of businesses and organizations supporting seniors whose mission is to enrich the lives of seniors in the Winnipeg area. When he's not in the office, Andrew can be found out for a run or enjoying the parks and patios with friends. Welcome, Andrew.
Thank you very much. Good morning.
Our second speaker today will be Dewayne Osborne. Dewayne is a legacy giving expert and will share with us some great information on charitable giving. Dewayne is the Vice President, Chief Compliance Officer, and Head of Philanthropic Services of Cardinal Capital Management. Prior to joining the firm in 2017, Dewayne worked for 16 years at Lawton Partners, most recently as their Chief Compliance Officer. Dewayne is one of Canada's leading authorities on plan giving. He is a certified financial planner, chartered professional accountant, and certified general accountant professional. Dewayne has spent over 20 years advising donors on making significant gifts and starting up their own charitable foundations. It is very easy to see why Dewayne is a highly sought after public speaker and consultant. We are so fortunate and lucky to have both of these gentlemen with us today. Without any further ado, Andrew, over to you.
Very good. Thank you very much. Just going to share my screen briefly. All right, thank you for bearing with me. So good morning again. My name is Andrew Torbiak. I'm a lawyer at the law firm of Tradition Law in downtown Winnipeg. Briefly about my law firm, we're about 8 lawyers. We specialize in all things wills and estates. So myself, I'm an estate planner, meaning I draw up documents such as wills, powers of attorney, and healthcare directives for clients. And I also assist with administration, by which I mean helping folks or let's say executors named in wills administer the estates that they've been put in charge of. Also at my firm, we do litigation, meaning fighting, all things related to estates. I try to shy away from that. I prefer to be meeting with folks who want to be seeing me at the time that I'm meeting with them. Today's topic is just in general, from my perspective anyway, a review of estate planning 101, so to speak. So what's a will? Why do I need one? Same thing with powers of attorney and healthcare directives and how those documents might interact. So what we call a complete estate plan should consist of at least these 3 documents. So the last will and testament, which is only effective after a person passes away. And then we have the power of attorney and healthcare directive documents, which are only effective before a person passes away. So legally speaking, there is no overlap between a last will and the POA and the healthcare directive. What I find is that's sometimes a misconception. Oftentimes folks are confusing their executor appointment in their wills with their power of attorney. And hopefully one of the things I'm able to elucidate today is the difference between those roles. But just generally speaking, those are the 3 documents that I'll be talking about today. So possibly the first question that I have arise when I do presentations like this is, firstly, why do I need a will? What happens if I don't have one? And maybe more importantly, do I really need a lawyer to write it? So why do you need a will? The 2 main purposes satisfied by drawing up a will are, 1, appointing the person who is in charge of your estate. That's called your executor. That person's job is to call in the assets of your estate, hold them responsibly until such time as they can be distributed, identify debts, identify taxes, pay both, and then distribute the remaining estate according to the will and according to the law. If only it were so easy as just that sentence. There's, of course, a million other nuances applied to that, but for today's topic, that's sort of where we can leave it. The other main purpose of writing your will, pardon me, is to lay out a plan or a scheme for how your estate should be distributed. And sometimes that's quite straightforward. Sometimes that's just evenly between my children if my spouse and I have passed away. Other times it's not as straightforward. It's in your will that you can set out all of these decisions. You setting them out in a legal document in writing is sort of the prescribed form for a will. So it can't be verbal. You can't tell people what your wishes are after you pass away. For now anyway, it's not allowed to be made by video or even digitally, by which I mean, say, typing it up or something like that and just saving it on the computer. Probably that will develop, but for the moment, it's quite archaic. I'm not using quill pens, but I am still, signing pieces of paper. Now, why do I need a lawyer? So firstly, I'll just say, here's a bit of a disclaimer. I'm a lawyer who writes wills. So you can take my response to that question with a grain of salt if you please. Obviously, I'm a little biased in this area, but if you aren't using a lawyer, you might be writing your will yourself, or potentially using some other kind of service. Let's call those do-it-yourself wills. So for one thing, they're hard to decipher exactly what the will writer's intentions or wishes were. Remember, you're the star witness, and if somebody is looking at your will and trying to interpret it, it might mean that you've passed away and you're not around to answer some very pressing questions. Self-written wills often contain contradictory or confusing instructions that might actually require a court to step in and answer questions that could arise from those contradictions. The other most common issue we have with do-it-yourself wills is just they haven't been executed or witnessed in a correct way. So all of a sudden, what we're dealing with is a will that was, let's say, written for free on just any piece of paper, but it wasn't executed properly. So now, for all the money that person might have saved in writing the will themselves, the estate might be hiring a lawyer to attend to court to give evidence to the court as to why this should still be enacted or perfected as a will. So it's what you'd call penny wise and pound foolish, let's say. This third point, it says costs of going to court for advice and direction. That's more or less what I'm alluding to. I don't know what this will means exactly. I'm the executor. I don't want to get this wrong because I can be, looked at by somebody who's been jilted by my actions. Now I'm forced to go to the court, spend that money, and get answers to my questions. Fourth point, it's more likely for there to be unintended consequences. And fifth point, lawyers are trained to ensure that your wealth passes to the person or people that you wish it to, and are trained to do issue spotting for you. Issue spotting that sometimes people don't do themselves because they don't believe it to be terribly complicated. 10 out of 10 phone calls I get with respect to wills, the folks say it's very straightforward. 9 out of 10 times they are correct. It's that one time out of 10 where I start raising issues like blended families, beneficiaries who might have special needs, U.S. assets, certain tax effects that take place after a person passes away. That one person out of 10 starts to realize, okay, this is a little bit more complex than I realized. Glad I called Andrew. You get what I'm saying? Okay. Now, if you pass away without a will, the government has already written one for you. So we have this law in Manitoba called the Intestate Succession Act. If you don't have a will, this is the statute in Manitoba that lays out how your estate will be distributed and who can be in charge of your estate. It gets messy. It's very cookie cutter. It doesn't, factor in what the dynamics are in your family. It doesn't factor in what your wishes might have very well been. It paints with a broad brush, and it simply says, here's who gets what. That's it. For the most part, it's sort of just your next of kin in a gradually widening arc. By that, I mean spouses, children, grandchildren, parents, aunts and uncles, cousins, second cousins. As a digression, I'm currently working on an estate where the person who passed away didn't have a will. He did not have surviving spouse, children, parents. He had 16 aunts and uncles. Only one of them was alive. He had 20 or so surviving first cousins. Anyway, long story short, I have to track down 39 people who are entitled to a share of this estate. Anyhow, if you don't have a will, only a certain class of people can apply to handle your estate, known as an administrator in that case. So if you haven't appointed an executor, that's through a will. A court-appointed person to handle your estate is called an administrator. The same people are able to apply as who might inherit from you. So next of kin. There's one added wrinkle to this, which is only residents of Manitoba can apply to be administrators. That right there might be reason enough for many folks to go out and get a will simply so they can use their will to point to their one child in BC or wherever to say, they're my administrator. Now I don't have to, or executor, excuse me. Now I don't have to worry about who's going to handle my estate when I pass away. Good. So as I've sort of alluded to before, the main elements of a will: 1, just putting somebody in charge. 2, laying out the distribution of your estate. It sounds like that more or less goes without saying, but the importance of laying those things out in your legal document in such a way as to be binding on your estate is you have made those decisions. They might be decisions that a beneficiary of yours or somebody else might disagree with. However, you made the decisions. And guess what? In this situation, you've passed away. So what are they supposed to do? They can sort of shake their fist at you up in the sky, and they have to live with what you decided. It's always best that you make those decisions as opposed to leaving certain decisions to people who are surviving. Because when there are things up in the air after you've passed away, that's when I see folks unhappy walking through my office door to go and meet with a colleague of mine who does litigation. And those fights are perhaps one of the main reasons that you might consider doing a will. In the distribution of your estate, we see a couple points here. Firstly, you can make gifts of personal items. That might just be, keepsakes or heirlooms or just tchotchkes and sentimental value items that you'd like to make sure get to the right person. It could also be monetary gifts or donations. So you can specify amounts so as to say, I'll serve you of M a little bit here. I wish to direct $50,000 to the Asper School of Business to be put toward the entrepreneurship program. That comes off the top of my estate. This is something that we'll be touching on a little bit later between myself and Dewayne. You can also direct specific assets, like not just monetary gifts, but the cottage or land or your corporation or your house or whatever that is. And then last but not least, you divide the residue of your estate. The residue, as the name suggests, is what's remaining after all three of those points above have been dealt with. And most commonly, we simply see, in my will, I give the residue to my spouse. And if my spouse has passed away, I divide the residue evenly between my children or my nieces or nephews or whatever that is. The purpose of using that general language, division of residue, we're not being specific any longer, is simply to direct your executors to put the rest of your estate into one big pile. If you've left 3 residuary beneficiaries, to cut that pile into 3 smaller piles. The piles themselves could be made up of different types of property or assets. The piles just have to be the same height, so to speak. So we have the 2 main purposes or elements of your will, executor and distribution. And then we see 3 other points here. In your will, you can establish a trust, which trust will not take effect until such time as you pass away. There are specific reasons for why you might consider a trust. One simply might be a beneficiary who has special needs. Another might be that your beneficiaries are a little young to inherit a bunch of money at a certain age. You can establish a trust for those people until they reach your preferred age of, let's say, fiscal responsibility. You can use your will to appoint guardians if your children are under the age of 18. And of course, you can use your will to lay out wishes in terms of, say, remains or funeral. So that's a very shallow dive into what a will is, what it's for, and why you might consider doing one. What I next like to discuss is what an estate is, why certain assets might fall into an estate and why they might not. I think it's a common misconception or a misuse of the term estate simply to refer to all property that you might leave when you pass away. However, that's not really the case. You should consider an estate to be a vessel, a bucket, and only certain assets are going to go into the bucket when you pass away. So some assets are excluded from the bucket. For example, on this slide, we see joint property, so real property like your house. If you and your spouse are both on the title of your house, when one of you passes away, that house does not fall into your estate bucket. It simply passes on to the surviving title holder in most cases. So you don't have to worry about the house falling into the estate for legal processing upon the passing of one spouse. Same would go for joint bank accounts between spouses, and I'll return to that point in a slide or two. So if you pass away and there's a joint account holder who is your spouse, that account continues to operate just as if you were still alive. Next, we have beneficiary designations. The most common example I would use would be would be a life insurance policy. So the purpose of this life insurance policy, perhaps, is to ensure that your spouse or a dependent of yours is financially provided for if you were to pass away. Let's say if you were, or the chief breadwinner, or simply to replace your income, regardless if you're the chief breadwinner. So we have a life insurance policy for $1 million. It's not $1 million that you own during your lifetime. Now, all of a sudden, it exists because you passed away. On that policy, you've attached your spouse as a beneficiary. You don't want that $1 million to be waiting again for a legal process. So because you've attached your spouse to that insurance policy as a beneficiary, it goes straight to them. It doesn't fall into the bucket again. Another very common example would be registered investments like RSPs or tax-free savings accounts. If you've attached your spouse as the beneficiary or successor annuitant, same deal. Those assets carry straight to your spouse on a tax-free basis, which is nice. They don't make a pit stop in the estate. You don't have to see a lawyer, to deal with those assets if they're not falling into the estate. It's very easy. No muss, no fuss. In the case where, let's say, the second of two spouses has passed away, there was a house, there were some registered investments. There's no longer a surviving title holder. There's no longer a surviving beneficiary on a registered investment. Those assets now flow into the estate. So, what's an estate? As I've sort of been alluding to, your estate is everything you own solely. In other words, assets you hold that nobody else has any right over. Nobody else surviving. So they fall into your estate bucket, and your executor picks up the bucket with all the assets, and he reviews the will, pays tax, pays debt, and then he takes assets out of the bucket in accordance with the will that you've written. So I've already sort of excluded certain assets. So it does not include your estate will not include joint property and joint spousal accounts. If you have a joint account with your child, and if the reason for that joint account is just convenience to assist your child in helping you with your affairs, that account falls into the bucket. Good, but the following do not again. So investments that you've already attached somebody's name onto as a beneficiary, assets held by a corporation. So if you pass away while holding shares to, let's say, a private corporation, medical corporation, legal corporation, small business corporation, whatever it might be, the person who passes away, they hold the shares only. They do not hold the office that the corporation owns or the bank account in the corporation. They hold the shares, which creates access to those corporate assets and decision-making power to corporate assets. But it's not to say that everything in the corp will fall into your estate directly. Now we're getting a little nuanced, so I won't go much deeper than that. And then assets that you may hold through a trust.
Andrew, if we could at this point introduce the concept of the graduated rate estate.
Certainly.
Because it's important to my part. As Andrew alluded to, you have to create the estate, but for tax purposes, and pretty much tax advisors know this because it's been around since 2014, but with charities since 2016. As the estate has to be classified as a graduated rate estate in its first year. And there are some fairly straightforward mechanisms needed to fulfill that obligation. But one of the big ones is the deceased has to have a social insurance number. So in the absence of having that SIN, you can't establish a GRE and you're going to get punished for the tax side. So when you see this slide, if you just write on here, you guys, when you get it home, GRE, important, I think that'd be very helpful. So thank you, Andrew.
My pleasure. Thank you for raising it. And briefly, a little bit more about a GRE, graduated rate estate. So firstly, in Canada, trusts, which an estate is a trust, trusts are taxed on income at the highest rate there is. So trusts and millionaires taxed at the same rate. Your estate is a trust. A trust is simply a holding place for assets for the benefit of others. However, estates are granted a specific, let's say, benefit by Canada Revenue Agency to be taxed for the first 3 years of the existence of the estate. So somebody passes away on January 1st of 2024 until January 1st of 2027. That estate will be taxed at the marginal rate that that person enjoyed during their lifetime, therefore not at the highest rate. I guess 36 months is sort of a line in the sand where, by and large, most estates should be dealt with. And it allows you and your tax and legal advisors, an appropriate amount of time to take advantage of lower tax rates, file tax returns for the estates, and get assets out. When somebody passes away, the way an estate registers to be a graduated rate estate is simply filing a trust return with Canada Revenue Agency saying, check, yes, we would like to have GRE status. All right. So thank you, Dewayne, and I hope that's an appropriate reference to GRE for your purposes. Good. So we left off more or less trying to define why assets fall into an estate and why they might not. So this is a closer look at joint property. This is my attempt at, let's say, graphic design. So we have two joint owners, and they overlap. They are both considered full owners of a single property, and if one of them passes away, it's the remaining holder or owner who continues to maintain title. There's no portion of the title, in other words, that falls into the estate. As you can see, I've kept them separate in my two-dimensional schematic here. Good. Lawyers tend to fill the space and time that they've been allotted with speech, so I'm just going to continue on for the sake of keeping up and making sure Dewayne still has some airtime to use. So passing wealth by beneficiary designation, you can see examples of certain assets that you could pass directly to your children, let's say, upon your passing. There are certain reasons why you may and certain reasons why you may not wish for your assets to pass directly to your children. For example, an RRSP or a RIF. When you pass away, the remaining funds in your registered retirement savings plan or your RIF are deemed to have been taken out by you in your last year of life. In other words, they are included in income for your last personal tax return. A very common error or issue that we see arise is a parent says, well, I'm told I can save taxes or something along those lines by attaching my child to my RRSP, and they get it directly. That's fine if there's only, let's say, one child and that's the only beneficiary. But if RRSP goes to child 1, child 2 does not get a share of it. And believe it or not, what actually happens is the full amount of that RRSP for tax purposes is included in the estate taxes that it must pay. So now all of a sudden, child 1 makes out with the whole asset, child 2 gets nothing, and child 2, through their share in the will or the estate, is actually paying a portion of the taxes. So that can be a problem. Not attempting to make a sales pitch by any means, but just sort of harkening back to that question, why would I want a lawyer to write my will? It's very basic issue spotting like that to make sure that injustices or inequities like that don't arise. Good. So what you'll commonly find a lawyer will advise you is, if we're now dealing with children, that is not a spouse, as your beneficiaries, we'll mostly advise you to direct certain assets through the estate. So if the RSP again travels through the estate now in this example, the RSP, the money in the RSP is now there to pay the taxes triggered by the RSP upon a person's passing. The remaining money from the RSP will then eventually trickle down to the children after taxes have been paid. Now, perhaps for the sake of this presentation, one bubble that I could have included, say smaller above here, might be like your favorite charities or a certain post-secondary education institution. If you are making donations through your will, those donations can only be satisfied from money that's in your estate. So if all of your assets have actually passed this way, there is no longer anything in your estate, potentially, to cover those donations. And so now all of a sudden, your wishes, your intentions are frustrated. We're now sort of morally relying on, let's say, your children to fulfill those donations. By and large, they'll probably do that. I can't guarantee that they'll do that, but they'll probably do that. However, let's say child one says, okay, mom, she said 50K goes to the Humane Society. There's nothing in the estate. We received it all directly, but sure, I'll put up 25K. And child two says, forget it. No, you pay it all yourself. Why do I have to? Because child one and child two have been fighting for years or whatever it is. Now we have an issue. We can no longer morally rely on the children, and by no means am I trying to cast aspersions on your children, hypothetically speaking, to fulfill that gift. So over to here, we know that because it's in your will, your executor is legally bound to make gifts when there's money to pay the gifts in your estate. Those gifts get made above here. The remainder, let's say if they're residual beneficiaries, then comes out for your two children. The difference between these two slides solves a huge proportion of issues that come up in estates. Okay. I am going to fly through these last few sections with respect to power of attorney and healthcare directive. And then Dewayne, I hope and pray that I leave you enough time. So very briefly, a power of attorney is a legal document used to appoint somebody who can manage your property, money, taxes, bills, personal business, if you are ever incapacitated. It's only effective while you are alive. It has no effect after you pass away. That power shifts from your POA to your executor in your will. They might be the same person, but two different documents govern at different times. You can make your power of attorney effective right away. So you can say, I'm appointing my spouse and my lawyer's son who's never going to put a toe out of bounds. I'm going to make my power of attorney effective whenever. I know that my spouse and Andrew will never overstep. Or you might say, Andrew's been a little shifty. I trust him, but only so far. And so I don't want my power of attorney to be effective for Andrew to use until he absolutely needs it, which we describe as a springing power of attorney, which only springs into effect if you lose incapacity, which means a doctor has sort of assessed you and says, this person can no longer safely, responsibly handle their own affairs. Your power of attorney should almost always be written to be enduring, by which I mean effective even after you lose capacity. Therefore, it never needs to be renewed or confirmed. If you said this document stays in effect after I lose capacity, you're safe, you're covered. It will be there until you pass away. Good. I will continue on. Scariest slide, perhaps. If you don't have a power of attorney, and if you lose capacity, that likely means that you can no longer, let's say, go to the bank to make sure that your money is firstly there and protected, and secondly, to pay your bills or file your taxes. Or if your house needs to be sold sign off on the sale of your house. So in that case, there are essentially two options for you. One is, let's say your next of kin or somebody would have to apply to the court to become what's called a committee, which is essentially a court-appointed power of attorney. Very expensive, very troublesome, very onerous requirements and restrictions placed on the person making that application. The other alternative is the public guardian and trustee's office of the province. Those are strangers to you, effectively becoming able to handle your affairs and make your decisions and charge you to do it. I think if there was a representative of the PG&T's office here today, they would say, we have enough clients, we don't want your business. Consider doing a power of attorney. Last slide, and then Dewayne, please jump in. A healthcare directive. Very similar to a power of attorney. It's used to appoint somebody to make decisions for you, if ever you could not yourself, except those decisions would be related to your medical and healthcare decisions, again, if you're incapable. So you point at somebody and say, that's who you ask if I'm ever, knock on wood, suffering from some condition whereby I cannot make my own decisions and give my own directions. I'm always the first person to say you don't need to pay a lawyer to do this. There are free online options under the WRHA or the Dying with Dignity website. They're simple, very boilerplate documents which you can print out, fill in, and sign to elucidate whom you would like to make decisions for you and what kind of decisions you might like somebody to make. Thank you very much. That was a little bit of a skim over on those last two documents. However, at the end, when questions arise, I can certainly readdress certain topics. And thank you. Okay, Dewayne.
Wow, something that's free. Thank you, Andrew. Outstanding. I was chuckling all during the session because Andrew was definitely probably banging up a lot of the points I'd like to make. So thank you, Andrew, for that great introduction to what I want to talk about. And that is now that you have done all those things that Andrew just mentioned, you now have a will, you have set things up. We're going to talk about legacy planning. You can go to the next slide, please. So again, you have the will, and this is where you have dealt with all your other beneficiaries. Everyone else is comfortable, and now you want to do something more. So as Andrew said, you want to make a gift to the charity. So you can actually do that by using will language and naming a qualified donee or a charity as your beneficiary. So aka the gift now, because after 2016, and this is important, people may still think, well, the deceased made the gift. Well, after 2016, you were deemed, everything is deemed to come from the estate. So, and again, a deeming provision means nothing actually happens. It's like me deeming my son to clean his room. Nothing actually happens until he does it, but you are deemed to have disposed of everything and it transfers to your estate. Then your estate makes the gift no matter what you have put down or tried to do. So that's a new rule from 2016. As Andrew also pointed out, there are exceptions that you can make gifts from existing insurance contracts. You can name beneficiaries to be a charity. And then, as he showed in that slide, you would see things passing right past the estate and going straight to the charity. Same thing with your designation beneficiaries of your RSP and your RIF, but do understand the tax still goes to the estate. You don't get around that one. It's just now you're going to get a nice tax receipt to go into the estate to deal with the tax part of it. But again, using caution there, as was pointed out, you do sometimes need proceeds in an estate to deal with things, but you're going to get a tax receipt to offset all that income. It's basically a wash from a tax perspective when you do an RSP, because it's going to come in and then basically go out in the tax credit. It's going to kill it. Let's go to the next slide, please. So I gave you very simple examples. I'm sure, Andrew will be laughing at these because they are super simple. But specific language, as he said, specific gifts, you can make specific gifts to charities. I leave the proceeds of my RSP/RIF, and I suggest the plan number be in there to ABC charity. Okay, you're naming a specific property. It's this particular thing, and only that thing is going to them. I leave $200,000 in cash to XYZ charity. Those things are great. Just I've also seen situations where those things have disappeared. They've been gifted to somewhere else, and nothing's been revised in the will. And Andrew didn't mention, you should have your will revised occasionally just because life changes. In this case, particularly with the charitable contributions, if you're doing specific property, make sure that property is actually still there. Residue gifts, as we said, after everything else is dealt with, you got this pile at the end called a residue. So I've quite common see 10, 20, 30% of my residue to go to charity, the balance to my other beneficiaries. I leave 1/4 of the residue to the charity. I've actually seen people put maximums in there because they don't really know how much they have when they die, but they've actually said to a maximum of X dollars, say 100,000. That's to kind of control it, because what if you won a lottery and you got $30 million in there? You don't want that much money going to the charity. Word of caution on the RIF RSP beneficiary designations. Some forms don't permit you to do it. Some companies only allow spouses and or the estate. So do check the company holding your RSP or RIF to make sure they got the appropriate form, and you can actually make that direct beneficiary designation. Otherwise, it's very simple. It goes into your estate and then comes out that way through your will. Next slide, please. Why do you make a legacy gift? Well, the first foremost reason is you want to help charity, and the second most important reason, or sometimes these flip-flop, and that's you want to give back. You've been successful in your life. Maybe everybody else has enough, so I want to give back to charity. Another reason for guys like myself and Andrew and other people who deal with the tax side of it is we don't want you to pay any more taxes than you have to. And remember, you're deemed to have disposed of everything you solely own in the year of death. So all that is going to come into your income in your final year. Your RSPs, your RIFs, those balances are all rolling into income. So you're quite wealthy at the time you die, and you need to make sure you deal with it if you wish with a tax receipt. And that's why I mentioned and we discussed the GRE, the graduated rate estate, because if no matter what you do, if you do not put your designation in your will, if it does not come from a GRE, you cannot deal with any of these individual taxes. There is no way to have that relief come back and help you. So it is absolutely essential that you have the graduated rate estate established in accordance with the rules. Why do you do this? You get a donation tax credit, which reduces your taxes payable for individuals. That's you could say 46 to 50% here in Manitoba. That means your after-tax cost of 100,000 cash is either 54,000, so it only costs you 54,000 to give 100, or if you're at the higher rates, only 50,000 to give 100,000. So you do get a benefit there back, and again a reduced tax. And we look at that and say, well, maybe you could give more then. If you're actually only costing you 50, you're prepared to give 100. Will you do 150? Will you increase your donation because you can afford to do so, because you're going to get a reduction in your taxes. Next slide. So very high level, this is how it works. You have a will. It makes a direction for the executor to transfer property to the charity. Again, you could also be a beneficiary election from an insurance contract. It just flows around. The charity will receive the property and again will issue a tax receipt back. But there are some conditions. It has to be property. Whatever's transferred must be property. It must be given voluntarily. It cannot be a court order or something else like that. It has to be voluntary. I have left this to X charity. You be careful about benefits to non-arm's length parties. Big one is readily determinable fair market value. If it can't be quantifiable, the court will not allow it as a gift. So don't give something it's got some obscure value. You're just muddying up the water. And very importantly, it has to actually be accepted by the charity. Until the property vests with them, it's not an actual gift. And trust me, the charity can actually say, no, we don't want that. And I'll cover that off in a few slides down the road. And as I've already mentioned, it can be a specific gift, naming a particular property, residue, or it can be what's called a designation, which is your RSP designation or your life insurance flowing around the estate direct to the charity. Next slide, please. Property to be gifted. Pretty much anything can be gifted as long as it has a readily determinable fair market value, cash, securities. As Andrew mentioned, there's a lot of wealth in their personal corporations and companies, and those shares or the assets of those companies can be gifted. Same with publicly listed, that's your IBM stocks and those things traded on exchanges, receive massive tax wins for doing that, which also afford to the estate. Artwork, collectibles, real estate, interest in property. The important thing is to check with the charity, and we're going to mention that in a few slides down the road. Be sure the charity actually can accept the property before you put it in your will to give to them, because they may not want it down the road. So next slide, please. What property should you not gift, particularly if you're trying to leave a legacy, okay? And that is, don't hand your problems to the charity. All right, if you have a problem asset, don't tell, well, I'll just gift that to charity and they can worry about it. I mean, I'm sure the university has a few of those things on its books. So I mean, garage sale items, your used furniture and stuff like that, that, you'd be better off to give to kids or give someone else. This is, again, because you're wanting a tax receipt, you're wanting a significant benefit back to you. Illiquid, meaning you can't sell items with no value. Property that charity might not be, except, for example, lots of crypto interest right now. People may not want crypto. It's a very volatile thing, and the charity could actually refuse it. And you're left now with no gift. And then you pop into another issue is you need people like Andrew to help you. Well, now what do I do? You got this piece of property I can't gift that was supposed to go to charity. Now what happens to it? Next slide. So how do you leave a legacy gift? Again, we're being very high level on this presentation, but you have to start off with, speak to your financial advisor. There's a lot of things to take into account, and life changes. And my goodness, there's a whole bunch of new rules coming in on January 1st. Legislation doesn't sleep. It's changed all the time. So your rules and things you set up maybe 5 years ago no longer would apply or wouldn't be as effective. So you need to revisit on an ongoing basis. Don't forget to name an executor, executrix. There's fine points. If you look at some of the slides from Andrew, the power of attorneys, for example, cannot make gifts. So if you lose your competency, you can no longer, you've been making donation all along, you can't. So you better be sure you've got proper language in place while you are able to do so. Executor, executrix understands you want to make a gift. Talk to them that you want this to happen. It's not just, okay, go ahead. Ensure you have, again, a GRE. You'll hear that term frequently used by me. Don't forget the proper name of the charity, but more importantly, its BIN number. It's its business identification number, its charitable number, because that number never changes, but the name can change. And there's been a lot of court cases out there, people fighting cancer and cancer care and everything because they don't, which cancer did you mean? The BIN number would have made that much clearer because it can only be one. Avoid lengthy directions in your will. When you're talking about charitable stuff, okay, direct the money to the charity and then have those directions to the charity, maybe in a what's called a donor agreement or something. So you're not clouding up it with 15 paragraphs of, I want this, this, and this, and this. Set up an agreement with the charity, transfer the money to the charity. Then you can just work on that agreement outside of the will if you don't wish to change the amounts. Keep things simpler. Discuss your intentions with your family, with your executrix, your beneficiaries, and the charity. Be sure they understand what you want to do. If you have any terms or conditions you wish to explore, things you want to fund, you have a lot of power to do that. You can only make recommendations. You can't make actual direction, but you can recommend. The charity can then accept to give that for research, that sort of thing. And then put those things in writing with the charity so it's there. And then the will becomes much more simpler. Give the charity here to use as per my agreement. And off we go. And then people like Andrew can come up with suitable wording that then will survive. It has the ability to survive time. Don't get cute and try to use a lot of complicated language in your estate or gift plan when it's going to a charity, okay? Just because you don't want to tie this thing up, you don't want to cause potential challenges. If you go to the next slide, we're going to be talking about that right now. And I've seen some stuff that, as Andrew mentioned with the RSPs, going to one kid and the other kid getting punished because now they got the taxes. I've seen directions and wills that people wanted to do that would have caused them a massive amount of issues. So just don't do that. Don't try to get too cute with it. Make it very clear what you want to do and communicate that. So your big issues, no GRE, be very careful, be sure there's one there. Will challenges mean more money, no potential legal help, litigation as mentioned, it becomes costs. Avoid complicated properties or directions where possible. Authority, my big point there is authority. The charity is going to ask you perhaps to send them the section of the will that details the gift. They may, if the executor has made a gift on behalf of the estate, which is permitted, show us where that person has the authority to do that, because that authority has to be given by the testator. They do that because otherwise you don't have a gift. So so if they ask for it, don't be offended. They need it to verify donative intent. And that's, of course, taxes not paid. Actually, CRA can come back and seize property that was gifted because they want their tax money. They will get it somehow. And try to avoid the residue gift loop. That's where you keep getting more tax receipt going back into the residue, and you create this ongoing loop. You can kind of close that off with proper language. And that's my stuff. Charlene, I see you popped on there.
Yes, thank you so very much, Dewayne and Andrew, this has been so much great information. I know that we are coming to the end, but I do have a question in the chat that I wanted to ask from a participant. Do you have any particular comments about the situation of a single person never married with no children?
Well,
Sure.
they have one, and that's CRA. Just so they remember that. There's one child there waiting on some money. Go ahead, Andrew.
Certainly. That was a question from Anne. Thank you, Anne. And I've typed out a bit of a blurb, but I'll gladly make sure that everybody benefits from this answer. So in a case where a person does not have a spouse, does not have a child, they have what I would call sort of less obvious next of kin, less obvious people who they might have wanted to inherit from them. I would say to a person like that, you might actually benefit from having a will more than somebody with spouse or children. Reason for this is, for one thing, I'll put it this way, it's your pie. You can cut it however you want. There are people, or let's say in that situation, people have less of a moral entitlement to your estate than, say, children might feel they have to their parents' estate. So when I say it's your pie, you can cut it how you like. That can include friends, children of friends, your chosen charity or your place of worship, or, you know, a whole bevy of family members. But just make sure you do state those wishes in the will, because if you don't, now all of a sudden you are, or your estate is, embroiled in the situation I described earlier, where potentially, though rarely, your lawyer is now dealing with 39 beneficiaries across North America and trying to track people down. So to avoid that, if you simply write out your will with 10, 20, whoever, favorite people or charities, you will save so much time and effort after the fact, after you pass away.
Awesome. Thank you. So we are at our time. Again, a great big thank you to Andrew and Dewayne. The additional questions, again, please reach out to us. We will be more than happy to get those answers for you. On behalf of the University of Manitoba, as well as the Plan Giving team, we wish you all a wonderful day. Thank you so much, guys. Bye-bye.